Good morning, everyone. I'm Bridget Polachine, CEO of the Institute of International Bankers, and I want to thank you all for joining us for this morning's webinar on eDiscovery and how to use analytics to rewrite the discovery paradigm. We're thrilled to be co-hosting this morning's session with Exiger, an IIB Gold Associate Professional member, as we borrow from their expertise, along with another IIB Gold APM, Goodwin Proctor, to talk about all things eDiscovery, including the methodologies that enable the effective use of technologies such as natural, which I might need help on that, natural language processing, named entity recognition, and continuous active learning. I know that this will be yet another insightful and practical webinar that you'll be able to reference frequently. Just a few housekeeping items before we begin. Today's webinar is eligible for CLE credit, and during the session, we'll announce a 5-digit verification code. If you'd like to receive CLE credit, use the link that was provided in your registration confirmation email, and you'll need to complete the online CLE verification form. And you'll have to make sure to include the 5-digit verification code when you fill out the form. Once the form is submitted and verified, we'll send you an email with the completed form for your signature. Lastly, even though we are in a virtual world, we want this seminar to be interactive and tailored to you. So please take advantage of the Q&A function in your Zoom window to ask questions. The speakers are going to go through the presentation, and in whatever time at the end, we'll address your questions, and those they're not able to get to, we'll follow up. So now, without further ado, and knowing how much material there is to get through today, I'd like to introduce our panel. Michelle Briggs is a counsel in Goodwin Proctor's litigation department. Ryan Bilbray is a managing director in the Exiger intelligence practice. He's based in New York. And last but not least, AJ Strollo is a director also in Exiger's New York office, where his primary focus is on building the eDiscovery function at Exiger. Thank you for being here, Michelle, AJ, and Ryan. And with that, I'll turn it over to you.
Hello, everyone. We'll go ahead and introduce ourselves first. Michelle, do you want to go ahead and introduce yourself first?
Sure. So I'm Michelle Briggs, as we all know. So I'm eDiscovery counsel at Goodwin Proctor. I am based in Boston. I've been in the eDiscovery space for a very long time, probably since before eDiscovery was actually a term, eDiscovery. And so putting this together, we all had a great time talking about the technologies that existed, almost nearly 20 years ago, and how they've developed over time. So in my practice, I counsel Goodwin's attorneys, bringing them up to speed on the latest technologies, as well as our clients, and work on a lot of investigations, litigations, responses to government inquiries.
Thanks, Michelle. I'm Ryan Bilbray. I'm a managing director with Exiger. I have 28 years experience in disputes and investigations. I've spent my entire career doing that. Much of that time, I've had a strong focus on eDiscovery. Our practice at Exiger is committed to an analytics first approach to eDiscovery, and that's what we're hoping to tell you a little bit about today. AJ?
Thanks, Ryan. So my name is AJ Stroll. I'm a director in the eDiscovery team here at Exiger. I've been in the eDiscovery space about 10 years now, give or take. I'm a bar admitted attorney, really focusing on the review and analytics aspects. So I bring that flavor from both the legal and technology aspects to this, and that's really where my interest lies. So it lines up very well. But without further ado, let's go back to Ryan to really introduce us to what analytics at eDiscovery is.
Great, thanks, AJ. So analytics means a lot of different things, both in eDiscovery and elsewhere in the world. Here, what we're referring to is the use of systemic technology processes to identify entities, patterns, relationships that are found in structured data, things that like databases, and unstructured data, an example of which would be email, with the goal of discovering useful information, suggesting conclusions about that information, supporting decision-making within a company, and driving insights into the data. Analytics are generally dynamic in nature. And what that means is that what you see, the result sets that are coming out of an analytics process are adapting and they're changing as additional information is learned, is added. So it's not just a fixed point that you're looking at. It's constantly shifting as new information is understood. And the final point on this, analytics are generally, we're talking about our computer algorithms that are kind of happening in the background. They're carefully developed and tested, and then they're presented for use by humans in a variety of platforms.
Just as a quick kind of baseline, what we have up is the electronic discovery reference model, EDRM for short. There's been some kind of updates to this along the way. Not much has really changed though. This has been pretty much the framework for quite some time. I think this model comes to us from about, looks like, 2014. So it's a great reference point for really what might be termed like end-to-end e-discovery. So what happens with the data and the progression kind of throughout the litigation process. And we're looking at it in that linear fashion. It probably is not really accurate to view it in that way. There's a lot of back and forth components. There's a lot of interaction with those components kind of throughout the process, but it really is a great framework for discovery kind of from the start through to the finish. The focus here will be that review and analysis component. So that's really where we're going to spend the bulk of our time today. Just wanted to keep this up as a good kind of framework. Really the last kind of point around this is it focuses on litigation, but it really does have applications to investigations and really anything where you're trying to get a good sense of your data. So let's really take some time. We'll go into some examples of e-discovery analytics as well.
So as Ryan had said before, there are a lot of different tools and technologies out there to leverage. And, I implore you all to look into these with your service providers or any technologies that you have internally, and consider these all tools in your tool belt that you can pull out and use either in combination with each other or singularly, depending on what you're trying to get at in your data set. So some of the examples, and this for sure is not an exhaustive list, but some of the technologies and analytics that we use are those such things as natural language processing, which is essentially a translation of human language into computer-driven, readable and searchable format. Entity recognition, which I think is really a very strong piece of technology, which will recognize entities not just based on text, but a lot of other information around the language that is used. So for example, it will help you distinguish between, if you're talking about Charlotte, are you talking about the place Charlotte, or are you talking about an individual named Charlotte? Communications analysis is something that I use a lot with and social networking. So particularly in investigations, figuring out who's talking to whom when, if there's any kind of spike in communications. And also when you're entering into discovery and you're negotiating custodians, you may take a look at your communication analysis and your social networking, and you may figure out that you've actually missed a very relevant custodian who potentially is no longer with the business or the company, and nobody has identified that individual. Sentiment analysis or detection. Again, I think we all probably use this in terms of investigations, really seeing if any of it really reads tone into the emails that you're looking at to see if there's any kind of negative tone that's happening there. I don't know if Ryan, you wanted to jump in and tell us about some of the other technologies?
Sure. Let's see. So technology assisted review is it's developed over time, as we have up here on the screen. Started off as predictive coding, kind of called TAR 1.0, moved on to what's called continuous active learning 2.0, and it continues to progress and branch a little bit. But at the end of the day, it's using a computer to make a model out of human review coding decisions and then project those decisions on the rest of the data. And so it's when applied properly, it's a really great shortcut to achieve excellent results in a document review with a lot less time required of people putting eyes on documents. There's one other thing up here that I just want to mention, which is concept clustering. That's actually one of the older technologies. It's one of the first ones that kind of became available mid to late 2000s, which is grouping together documents that are similarly themed. And again, this is done by the system without human interaction in most cases. And what allows you to do is very quickly jump into buckets of documents that are that are similar in nature, hopefully. And we're going to get a little bit more into that later on. So before I turn it over to AJ to talk a little bit about visualization of these analytics, these capabilities are available to one extent or another in most modern eDiscovery platforms. Some have all of them, some have some of them, but they're implemented in different ways. And really the key is to find out which one you're comfortable with and develop expertise in that platform, or leverage the expertise in that platform so you can make the decisions about which of these are appropriate for any particular matter.
And that really brings us into the last piece about that. And this component really is true not only for analytics and what analytics will yield, but really quite a few data points that can come out of the document population. And what visualization really allows you to do is to take your data and really think about how you would have had to search that in certain platforms. You'd have to know search logic. You'd have to know exactly how to enter that information and what information you really want to do. And this allows you to take a look at it really in graphical form. And it's interactive to the extent if you start clicking into those charts and those graphs, you're actually building what could be a complex search and start getting some insight. So you're coming into this, and if you have some background as to what the matter may involve, or who really are your kind of key focal points, this allows you to get into those pieces quicker. If you really are coming into a matter and you're kind of in the dark about it, it also allows you to get a very good high level sense of some of your key topics or key participants. So there's a lot you can do really kind of from, we'll say, the dashboard component of a lot of these platforms without having to go into very detailed search logic and things along those lines. So it's a very powerful tool. And again, as Ryan said, really just to hit that point again, a lot of this is being done without much human input. So you're getting these kinds of reports without having to do a whole lot of heavy lifting. So it actually can be quite powerful from there. But really the next point, Ryan, is why does this really all matter?
Yeah, that's true. And and from a perspective of having been doing this in the days when none of that stuff was available, being able to see who's talking to who, the clusters, the way the documents lay out, it's an extremely powerful step forward in what we're doing. So that brings us to why are we talking about this? Why does this matter, particularly to you, to the people that are that are on this webinar today? Why does eDiscovery technology and analytics matter? Technology can play a major role in how to identify your data quickly and efficiently. We're going to keep coming back to that throughout the course of this presentation. The efficiencies that can be provided by these technology tools can really help address the cost considerations, as well as the eDiscovery obligations that you might have in a litigation setting. It's why we're talking about it today. It's also important, and we've referenced this already, but it's important to consider not only what technology is available, but the role it's going to play and the implications that the use of it has for a given matter. It's always vital to have experienced individuals involved, as most of these are not just plug and play. It does present the information to you, but there's human application of the systems that get you to that point. Most of these platforms require at least some degree of tuning and understanding of what's happening and what the system is doing to let to get those good insights into your data. So Michelle, I'll turn over the next section to you.
So, so anybody who is a practicing attorney or is still a member of the bar knows that lawyers owe a duty of competence, and that's very clearly laid out in the model rules of professional conduct, Common 8. And this has been highlighted yet again for us now that we are a year into working from home. The ABA came out with a formal opinion on March 10th about virtual practice. And included in virtual practice, they did remind us that commonly implemented model rules of professional conduct that apply and fall under this virtual practice world that we're in right now includes the duty of competence with technology and technology changes. So I feel that it's really, the timing is fantastic here as a reminder, and you guys are all on this webinar right now, so you're doing your part to make sure that you understand the technologies and the changes to technology and how they can be used. I think what you also will see and find in the case law is that incompetence is not an excuse for discovery misconduct. So there are numerous cases out there where corporations and or their outside counsel are sanctioned for failures in the discovery process related to technologies. And I think what we're finding now as well is that the technologies that our clients are using and our law firm is using has really changed over the past year when we all have been working virtually. And also in terms of that, I think that additional data is actually being captured and preserved, which is even more important while we're leveraging this technology to weed through information rather quickly, leveraging analytics. So circling back to technology assisted review, which Ryan talked about a little bit earlier, the first seminal case that we had where the courts had approved the use of technology assisted review was in De Silva Moore, and that was way back in March of 2015. So we're 6 years past that point now. And over time, the case law and the body of case law has really developed. And in the two cases that we have up for you here, a few years apart, what's important to know is that these two cases, when they came out, TAR 1.0 that Ryan had talked about before was the only type of technology assisted review that we were commonly using at that time. We have since then developed in the more commonly used technology now, the TAR 2.0 or continuous active learning. But it's really important, I would say, and I still do cite back to Rio Tinto very often when my adversaries push back on my clients and my firm using technology assisted review in cases. And what was very important that that Judge Peck said here was that in the 3 years since De Silva Moore, the case law has developed to the point that it's now black letter law that where a producing party wants to utilize TAR for document review, courts will permit it. And that was 6 years ago. And I will talk about a little bit later, it's still pretty surprising that it's not used more commonly. And there's such objection, mostly from the plaintiff's bar, over the use of technology assisted review. And one of the other things that we're also up against is another point that Rio Tinto pointed out for us was that TAR shouldn't be held to a higher standard than using keywords or a manual review. So that's something to keep in mind when you're going out and negotiating technology assisted review, the use of it in your cases.
Thanks, Phil. I'll take this opportunity for those of you that are earning CLE credit during today's session. The CLE code is 62010. 62010. And if you didn't have a chance to get that and you need it afterwards, please feel free to contact us. As I mentioned during the introductions, I've been working in eDiscovery since the very early days. And back then, like I said, it was very, very manually focused. What does that mean? Very basic culling and filtering. Keyword searches, they were crafted. Judge Peck once said that keywords are crafted in the dark by the seat of the pants. Which it doesn't mean that keywords don't work. Sometimes they do, and there's definitely an application for them. But search terms can be both overly broad and overly narrow. They require an understanding about what you're looking for, and how the kind of things you were looking for was discussed among the participants in the example of an email search over email. Traditional keyword searches are just inherently strict. They match the exact term, and we do have wildcards and some fuzzy matching and things like that. And as time has progressed, there have been some other, like dictionaries that do keyword expansion and things like that. But at the end of the day, keyword's going to find what you tell it to go find. It's not going on performing analytics. If you don't have a match, you're not going to see the document. In the early days, very limited application of analytics, if any at all. One of the first things that was invented was email threading. I'm not going to go into that in detail, but that was a fairly significant development. And then the next thing, really, the clustering that we talked about, also near deduplication, was a pretty big development. But at the end of the day, it was about armies that were being organized for document by document manual review. So as time went on, the time, the cost, and the volume pressures that were involved in this kind of matter really forced a change in the thinking about how we perform eDiscovery. And as the thinking developed, then the tools began to develop that provide some of the capabilities that we discuss. So that's the early approach, and AJ is going to talk a little bit about the more modern technology enhanced approach to eDiscovery.
Absolutely. Thank you, Ryan. And really, what we're talking about here is basically everything we were discussing as far as where eDiscovery analytics examples, where they come into play. There's a lot more tools at folks' disposal now. There's more platforms. There's more ways to go about it. And that's one of the key points. The other point is folks are looking into and applying analytics a little bit earlier in the process, and it's continuous, right? It's iterative. There's analytics applied throughout. So you may have some predictive models up front. You may have some concept clustering or some email threading or really a blend of all those features, but you're not stopping, right? As you're advancing throughout the matter, you're continuing to refine that approach to make sure you always have, in quotes, those right documents in front of the team at really the right time. And that's what's important. There's no hard and fast rule that we now move from analytics to review or from analytics to production. There's a constant back and forth, and that's why, going back to what we were talking about with the EDRM, that linear nature of that isn't necessarily the best way to look at it. So we're talking about things like concept searches instead of keyword searches. So we talk about or think about something in soccer, right? If you could search for soccer and it only brings up hits for soccer, or maybe if you have the wild card, some other examples, but World Cup, goal, things along those lines really might be associated with soccer. But if you're not searching for that, you wouldn't otherwise capture them. So the concept searching allows you to really start getting into things that get a little bit more in depth. And the other piece of that, what it's allowing folks to do, is really take that technology and basically, as you see it, as a force multiplier. So instead of needing those really large review teams, you might need a much more focused and kind of a smaller team who's going about in a way, to make sure they're drilling down to the documents that matter the most, right? It's leveraging what analytics is helping folks carve out. And still, again, some review component, there's still human thinking. So don't get us wrong. We're not taking that, or no one's taking that out of the process. It's just getting the team maybe some of that noise out of the way and getting into what's more likely to be relevant. Really, at the end of the day, what is it doing? It's helping to yield quicker insights into the data. You're getting a better and faster ability to make some decisions around the case. Some of the earlier approaches, you'd probably and presumably find that smoking gun email or the needle in a haystack, but it could take a very long time. It could be the last day of the review. So think of all the days that had passed or could have passed from there. Now you're finding those kinds of documents earlier. You're able to make some case decisions. And do we have a strong case or not? Is this one we need to consider settling, or maybe we should up the damages claim or something along those lines? There's a lot of different calculations, things like that could feed. You're also getting higher quality document reviews. And again, what does that mean? It means you're getting, the right sized review team. You may not need 75 people. The work of 5 can actually maybe help support something along those lines with the power of technology behind it. But you're also having them focusing on, again, those right documents. So a lot of the noise, things as obvious as maybe some industry newsletters, but really those gray area or those business as usual kinds of emails that were a little bit harder to filter out are easier to kind of push aside and say, let's focus on, some of the outliers, some of the things that might not otherwise get captured, and it does allow that. And that helps feed maybe some, more kind of predictable timeframes and just a little bit more kind of predictability around how long something might take. But that's not to say that, those earlier approaches aren't still used. And there's plenty of reasons why they are. And Michelle's going to help us go through those.
Yeah, AJ, and I just really want to highlight one of the things that you talked about that I really use in my practice is, convincing my clients to collect data for key custodians very early on in a matter, potentially right after the complaint is filed, to really try to gather the facts, to really build the case and know the strength of the case. So while Goodwin Proctor would love to take your money for a couple of years before we actually find out that, we're going to have to settle this case or take it to trial and the facts aren't really good for us, really digging in and finding out the facts early on and continuing that with leveraging technology. And even in my cases, if I'm not using it to cut off review, I'm using continuous active learning to try to review the relevant documents earlier. I'm leveraging the clusters to try to find similar documents to, if I find one bad document, is there anything more like that, to really build out the story. And in times we're going very early on to the client and saying, this is what you think your case is. Here is the law and here are the facts, and putting them together. You either have a very strong case, or you need to amend the complaint, or we need to amend our responses. And maybe we have a counterclaim. Maybe we should actually settle, because you can spend a whole lot of money on Goodwin Proctor litigating this, but ultimately in 2 or 3 years, this is where you're probably going to end up. So hopefully the clients really see the value in that, and then we'll come back and leverage my firm and our teams, leveraging technology to get better results. So those types of things that I'm doing are things that are in the background, where there's really no need to disclose or have a conversation with your adversary about what you're doing and how you're leveraging technology. So why are early approaches still used? And I still do leverage them for good. But for some reason, others are have fear of the technology, right? And they thought that the only way to go about document review is to have a meet and confer, identify a number of custodians in a date range, negotiate search terms, usually in a vacuum, and start from document number 1 to go through the end, and there you go. Other people will say that, you can only use analytics on very large matters, which is a complete misnomer. It works very well on small matters. Anything you can do to focus your review of these documents and remove the noise and get to the answer faster is going to be helpful. And truly, a lack of understanding, I think, is not necessarily true for the defense bar, but I think more for the plaintiff bar. They lack understanding. They also lack trust. They think that whoever's on the other side of the V is trying to use this to keep information from them, and in fact conflate what a technology-assisted review process looks like with what is actually being determined as responsive, which isn't going to change whether you're doing a linear review or you're leveraging technology. And I think all of these things, as I said, really, really wrap up with your adversary. And I will say for some of my institutional clients where plaintiffs firms have pushed back on them and you see the same plaintiffs firms over and over and over again, we sit down and have the conversation with our clients and sharing with them the litany of case law out there that approves the use of technology assisted review. So the courts are approving it. They're actually approving technology assisted review in conjunction with the use of search terms. So you can pre-call your data set. And that we really must fight it, because if we step back and cower and not spend the money on motion practice to be able to use that technology, they will continue to do this, and we'll be 5 years from now still going back and doing a linear review, which in numerous studies have been found to be very inefficient and not accurate. And what I want to say is that, when we're talking about this, not forgetting some of the older approaches that we used. So a really good example of leveraging technologies, not quite analytics, is I currently have a case where we're negotiating search terms. There are 2 issues in the case, and I knew that it would come down to a handful of documents that were likely circulated in different emails over the span of a period. So applying the search terms, looking at all of the attachments, I went in and I just did a simple search for all of the MD5 hash values, which are assigned to unique documents. And what I found there was I was able to cull out a large section of my population because the same document kept being circulated, but attached to a different email, so it didn't deduplicate out of my set. So there's a really old technology that you don't want to forget about, where you can identify and apply information to duplicates. And I still do the same thing with redaction. So redacting large files, making sure that you have consistency across redactions.
That's great. Thanks, Michelle. I think we've hit on a lot of these advantages. I'm going to restate 2 things. The whole purpose of this is to get you to the relevant and the key documents, get to the heart of the matter quicker and with less human effort, and therefore, saving money for, saving your money, or in the case of providers, saving clients money. And we do that by smaller review teams that can focus on those key documents that are likely to be relevant and make some better decisions about those documents. AJ, can you talk? I know Michelle kind of started hitting on a little bit, but can you talk a little bit more about how the old approach and the new approach, how those still fit together even now?
Absolutely, and it's nice to always have. So we really, I think, introduced this throughout the program so far, but to actually have a case behind it as well, and one that's fairly recent. This is only coming to us from kind of the tail end of last year, but that Livingston versus City of Chicago case really hit on so many of these points. So there was a very large data set, a lot of back and forth on the right, in quotes again, approach to the eDISCOVERY for the matter. Ultimately, the court, ruled that keyword searches could be applied, get the right kind of folks to do that, make sure that it's being run appropriately in the appropriate environment, and then the City of Chicago also wanted to apply TAR for ultimate review of those documents. I think it went from something really staggering, like millions of documents, down to just under 200,000. But that's still a large number, and that's just we shouldn't lose sight of the fact that you're taking a huge number to a very large number still with that. And ultimately, the city said we want to use continuous active learning for review. The plaintiff pushed back and said, that's not what we thought. We understood that we run these keyword searches and they'll screen for privilege, but everything gets produced. They're not reviewing them for responsiveness. The court really said, no, that's not what we said. And really the key is the defendant here is in the best position to figure out how to review their documents, and took it kind of one step further and said, not only that, but active learning or continuous active learning is really a review strategy more than it is a culling decision, that it does fit with keyword searches. There's also, there were some concerns about, how effective is TAR? What happens if the folks who are doing the review are making bad decisions? And the court highlighted that, a few things around that. First of all, incorrect review decisions are present regardless of what approach. If you're talking manual review, there's incorrect review decisions, and that could even be magnified, right? There's also quality control methods, and there's different checks and balances. A lot of them are built into the platforms, but there's extra steps folks can take. And the city here was really forthcoming with their proposed approach and their technology. So all of that is really kind of important of just highlighting that courts are getting that understanding that we were just speaking through as well, and they're highlighting all of those important steps for us to kind of consider. So I definitely don't want to belabor that, but it is nice to have a case that really backs up a lot of the points that we're going through.
Yeah, that's definitely true. And, we're going to spend the rest of our time with you today walking through some additional cases that each of us have personally worked on. It's important to note that we're going to kind of highlight, maybe one or two examples of how analytics were used in these particular cases. This should not by any means be looked at as an exhaustive list. Nor is it even exhaustive within the context of these particular cases. But we just thought it would be helpful to, instead of talking about it in the abstract, to talk about some things that actually happened. So AJ, you want to do that first example for us?
Sure. So we'll start with, in a more simplistic matter, we'll say, right, a small volume of data, or again, a relatively small volume of data, a single custodian really looking for a very distinct or evidence of a very distinct issue here, theft of or potential theft of trade secrets. And you probably don't have, the full realm of data sources that, these days exist. You email data presumably, and maybe some mobile data, but you're not talking about a whole ton of different data points, or at least not at this stage, right? And you could really get down to that point. You could do your communications analysis, and you could see, who is this custodian? Who are they speaking with? Are they sending documents or emails outside of the company that really should not be going outside of the company? Are they copying or blind copying themselves on emails, or sending emails to personal addresses, or all sorts of other things? And there's definitely other forensics approaches you could do, but we'll really focus on the predictive model aspect here. So we have just kind of an example of some of the kind of the reporting and the workflows you get around those predictive models. Again, each platform will have a slightly different flavor and appearance as to how it works. But really the kind of the end result of that is that folks will go in and make decisions, really just a yes or no decision as to whether it hits the parameters here. So is this evidence of theft of a trade secret or not? And then from there, the system will process those decisions and really apply it across the full population. So we have, I think, something around the range. This yields about 9,000 documents reviewed out of a population of about 450,000. The system took those decisions, scored those documents really from 0 to 1 or 0 to 100. Not quite specifically a probability. There's some algorithms that go into that. It's a little bit different. And again, all the platforms are a little bit different, but typically they're all having that same flavor. The closer you get to 1 or 100, the more likely it is to be relevant, or kind of the yes parameter for your model for those issues. And this is really just highlighting, you with a little bit of work, and again, still some human review component, you've actually gone in and said, okay, there might be a good set of documents we don't have to look at. And you're still pushing quite a few into review. You'd still be pushing a good set of these documents into review for production, for privilege and all that. But you've done a lot of work just via that upfront analytics with your predictive model. It's that active learning flavor as well. There's some back and forth that might happen, and you might see some of that score or those scores kind of start to move. But again, it's really something worth monitoring. Again, lots of QC checks you can do, but you're getting down, or you should be getting down to at least a focal point of those documents that are more likely to highlight where someone may be acting, we'll say, inappropriately as far as the data goes. So it can be very powerful, even for a very small matter.
Yeah, AJ, leave that slide up for 1 second, if
Sure.
if you would. So one thing just to add on, in that bottom right graphic there, it shows high, medium, and low scoring, and it shows the percentages. Well, part of the kind of the art to this rather than the science of this is deciding what is my threshold for something that is, quote, responsive. So in one of our practices is we will try to look at kind of the natural break point where you've got a kind of a gap where things are, above or below the line, and then test just above and below that line to see, okay, are things that are scoring at 70%, you go in and do a sample test of those. Are those actually responsive to what we're looking for? Look down at 65%. Are we seeing, significant numbers of documents that are actually responsive? Does that mean, it doesn't mean the model's wrong. It just means we need that. It helps us, identify where to set that threshold for, for ultimately either producing or considering for the case of litigation. So, yeah, but thanks, AJ. So I'll just go on. But the next example we're going to talk about. So we worked last year on a large matter, actually kind of a huge matter, multiple custodians, large financial institution covering multiple business units. It was a really complex data population, had email data, mobile data, chat data from multiple platforms, and the subject was alleged trader fraud. So we used multiple predictive models. So AJ just finished talking about the predictive models. We use multiple models covering multiple topics. We definitely use the sentiment analysis that Michelle was discussing earlier, looking for specifically identified behavior, things that are negative, things that are indicative of high pressure. We use the concept clusters, we use the entities, but the biggest thing that kind of was the springboard for us was the communications analysis. And this is not from that. This is actually from this is sample data, the Enron data set, but this is illustrative of what we did. And we followed the very similar workflow where we were able to look at key custodians and look at their network of communications. Who are they talking to? What are the volumes in which they're talking to those individuals? What's the direction of those communications? Is it all, a person sending a bunch of messages out, or is it a back and forth? Are we seeing communications at odd times? Are we seeing communications that, combining this with some of the other factors like the sentiment analysis, are we seeing emails that are showing indications of high pressure? And what that allowed us to do was very quickly get a sense of what was happening, what were the patterns of communication, and it helped us build out those models, the models that ultimately became the key of, the predictive coding that we spent the bulk of our time on. So when we combine all these things together, it was, we were able to do this. It's hard to say, it's always hard to put an exact, what efficiencies did we gain? But it was at least 50% in our review time, multi-million record set. And we were able to get to some really good answers, defensible answers that ultimately, were the basis for our productions to the other side in this. And we were able to do it very quickly compared to what it would have taken. And at the end of the day, we saved our clients a ton of money. They were able to get to some of those faster case decisions, as Michelle was referencing, with really a lower level of effort than I would have thought possible, in the recent past. So, for us, this was just it's a great example where we were able to bring our knowledge, our experience, and our expertise to bear to solve this problem on behalf of our client and really get to a good answer very quickly. So, all right, if nobody has anything else on that, then Michelle, you've got that third example that we wanted to talk about here.
Yeah, so I had a case last year where I did leverage technology-assisted review. I used the continuous active learning model. I did negotiate it with the other side, who was unsurprisingly skeptical about us leveraging the technology. There were a lot of meet and confers, a lot of explaining to them how we were proceeding, and talking about, right, as attorneys, we have obligations under the rules to find relevant documents and produce them, right, to the extent we've agreed to do so, and actually have to sign a verification under 26G that we have met these obligations. And we take them very seriously. So doing our predictive coding model, when we thought we were done and we had tested the documents that we didn't review, we thought, well, we did a great job, because there really wasn't anything left in that unreviewed population when we were cutting off review. But because we're really good at this and the work that we did up front, we had a basic idea and understanding of how many documents, how many relevant documents we think we should have found in our corpus review population. And we weren't there. And admittedly, this was a very difficult issue and a very difficult review. So what we did was we leveraged all the technology that was available to us to do a really good quality control check of the human reviewers' calls. And what we did was we found relevant documents. And then we also looked to say, okay, are there any conceptually similar documents? So we looked in the cluster of documents where humans had coded them non-responsive and started pulling through those documents and doing a re-review and focusing our quality control there. We also looked at duplicates. So were duplicates or near duplicates coded differently, and if so, why? And what I will tell you is that in some cases, not this case, but other cases, you can have potentially two documents that are nearly identical, but there is one little component of them that makes them different. And that's really confusing for a TAR algorithm. So one case that I'd had a number of years ago was the difference, something was responsive and non-responsive based upon whether it was an FHA loan or a non-FHA loan. And so you could have, as you can imagine, nearly identical documents, one's responsive and one's non-responsive. So in that particular case, we created a training tag, which was called conceptually relevant. So the concepts in those documents were relevant, and so therefore it trained as if it was responsive, but we didn't produce it. So leveraging that, that thought process here, we were really looking for the concepts of documents that were coded non-responsive that we thought should have actually been responsive. And what we found was, in fact, our model did work really well because all of the relevant documents or the additional relevant documents that we found weren't in the unreviewed population. They were in the review population where humans had actually made errors. And because it's continuous active learning and because you're training on a number of documents in the corpus, our model was still really good because it had the actual relevant documents and it was bubbling up to the top or applying higher scores to those documents that were ultimately reviewed. So leveraging the scores is another thing that we did. I think AJ was telling us that these predictive coding models score the documents between 0 and 1 or 0 and 100 and everything in between. And really what the algorithm is telling you, it doesn't really understand is that stuff in the middle. And so it's really good to grab some documents in the middle and see if you can part the C any better. And what we also did was we went in and we said, what high scoring documents that the model thinks are responsive did humans say was non-responsive? And really focused our QC on those pieces. And that's typically part of our process anyways, is leveraging that technology to see if there's a conflict between the human and the machine and try to correct either way. So perhaps that the human coded it non-responsive and it trained that particular way, and now you're getting similar documents pushed down with lower scores. So we're always working to correct. And ultimately, we did find a number of documents that that were eluding us, but not in the illusion set, the unreviewed population, in the reviewed population, but were coded incorrectly. And I will say in that case, I was working with a partner who wasn't as familiar with the technology, but was always on board with technology assisted review and seeing how we could very easily correct the issue that had occurred here, rather than re-reviewing every single document that had been coded non-responsive, is a full believer in the technology and the strength of the technology and analytics.
That's good. AJ, leave the slide up for 1 second. We do a lot of investigations work in addition to litigation work, and we actually use those same two processes you just described, the clustering, and but that's what's on the screen. We've got 3 different examples of how clusters can appear. in different ways depending on the tool you're using and how you choose to present it. But we use this as an early dive when we first get a document set and we have some general idea what we may be looking for in the investigation. This is great because we can dive in through these clusters and drill down and see what are they talking about, what's related to what, see similar documents. We also use the predictive coding, not in the sense of trying to get to that stability and get all the documents, but rather start coding, look specifically hunt out documents that have whether it's concepts or even keywords or communicators, whatever the case may be, that we know are exemplars of some of that bad behavior, and start build a model around it and do a fairly minimal amount of work. I'm talking about, maybe code a few hundred or a few thousand documents, and then look at what the model scored. And now let's go look at everything that's scored from 85 to 100 that a human has not looked at. And what we found is that it's really effective in finding other exemplar documents or related behavior that's helped us with our investigations. It's really, it's a really effective workflow that we've used, dozens of times over the last couple of years. So.
And I think it's really important when you're looking at all the technologies is that you're really focusing on what the end goal is and how much work you have to do and what do you have to find. So sometimes in investigations, if you find a handful of smoking guns, you're done and there's no need to plow through the rest of the corpus, right? Because you have your answer. Versus in discovery, you have an obligation to produce documents that are responsive to the claims and requests.
Definitely,
right?
definitely agree there. So cool. Okay, AJ, I think we're go ahead and we can move on to. So in the remaining time here, and I know we've got one question, and I don't know if anybody else can have a question at the end, and we certainly want to leave a few minutes for that. But this is what we want to leave you with. Methodology when using analytics is vitally important. Michelle just gave a great example of a quality control step using analytics that really helped them get to where they needed to be on their matters. That's vital. Expertise and experience is a must. You can't just rely on the software. And then hopefully we've shown you that there's no one size fits all approach. This isn't a single path that we go down, on any particular matter. It's generally a hybrid approach. It's a flexible approach. It's bringing those tools in our toolbox or tool belt, bringing those to bear on different matters at the right time in the right combinations. And what does that get you to? It really helps you address those things that we talked about before: the cost of the matter, the timing, deal with the data volume, and then ultimately reduces the amount of risk. Hopefully reduces the risk that's involved in the conduct of your matter, gets you to a positive result, a defensible result with minimum risk to your organization. So Michelle, any final thoughts?
Yeah, that this all takes work. So the old way, if you're doing it right, takes a lot of work. If you're coming up with search terms, it takes a lot of work. Understanding the technologies takes a lot of work. And really, the duty of competence, circling back to that, you're competent if you seek out individuals that have the competence. So, seek out those individuals, have the conversations with AJ, with Ryan, with me, really coming up with these strategies and putting them in place and making sure you have a defensible process. And for me, defensible process always includes documenting all the steps you took. So if there's ever a question, you can go back. And that's true in the investigation phase. If you're saying, well, did we actually go down the rabbit hole and look for these things? You can say, yes, we did. And here is what we did to get to the answer that we have for you today.
Great. AJ?
Yeah, and really just to build off everything, I mean, there's very simply put, there's no easy button. There are a lot of steps that go into this. There are a lot of considerations around the specific matter and what really you're looking for. What are the implications? Going back to what Ryan was highlighting as far as the predictive model goes, for one matter, your threshold might be safely 60%, but for others, you might have to go much farther back. There are still situations where those that, in quotes, that 20% range might actually still have quite a few relevant documents. And if you're in that litigation setting, you might have to go back back and kind of, take that a few steps back. And I think there are a lot of considerations around that. That's why it's just not a button and we say, this is the approach we're taking and we're done. There are a lot of considerations. One kind of like my final thought, and why not throw one more case out there. There's a case that came out of the tax court. It was a few years back at this point, 2016, the Dynamo Holdings case that really highlighted a couple of important points. And it was talking about, in quotes, kind of that myth of the human review and the myth of the perfect response. And I think the real takeaway from that is the expectation here, the standard is not perfection. Human review is not perfect. TAR is not perfect. Everything in between is just not perfect. It just needs to be reasonable. And that, I think, is the really kind of the bring it home of all those takeaways is your standard is reasonableness. Did you take the right steps? Did you have a process that really should have accomplished, what you needed to set out? And I think that really is something very important for folks to consider.
Yeah, definitely the case. So, hey, so we had one question sent in, and it's kind of a two-part question. I think we can address the first part of it. The question is this: law firms depend on vendors to perform AI and related services. Can you explain your vendor due diligence process, as banks have a rigorous process before approving a vendor? Michelle, is that something that you're in a place to talk about, how you do kind of check out the providers that you work with in this space?
Sure. And I think there are two things. So as you rightly noted, that banks have very rigorous processes. So our bank clients often do have their own vendors. So I don't think that I do anything different if it's a vendor that Goodwin is engaging or a vendor that's already been engaged by our client, is really looking at their technologies, seeing what technologies they offer, but most importantly, who are the people and the expertise of the people that are supporting those technologies, that are coming up with the workflows, that are assisting Goodwin, that are assisting our clients in putting together a workflow that's going to work. So you could have like your very shiny Ferrari of AI tools, and if you don't know how to use it and you can't drive a standard, right, let's just assume it's a standard clutch. If you can't drive a standard clutch, you're not going to go very far and get your enjoyment out of your Ferrari. So for me, it's the technology and it's the people that run the technology. And I would much rather have a lesser of a technology and greater people power of expertise to be able to leverage the technologies that are out there and that are available.
Yeah, that makes sense. I mean, coming from the other side of that, being on the consulting side or the vendor side, our company, actually, part of what we do is we actually do vendor risk management and model validation, things like that. So we're acutely aware of that relationship and what's required there. And one of the big things, I think this is this almost so obvious it goes without saying, but the security posture of your provider. It's vitally important. It's important to us. It's important to the law firm. It's important to the banks, because as we've seen, the risk of exposure of this usually extremely sensitive data is just too great. So, a well-developed, documented security posture, having the appropriate people in place, resources in place, technology resources in place, that's a key thing. It's something that we and I think I think most providers in the industry are definitely aware of and focused on. We'll send in a response to the rest of that question offline, if that's okay. And if there are no other questions, Michelle, thank you so much for joining us. AJ, thanks for participating in this panel. And we want to say thank you to the IAB for allowing us to have this time to speak to all of you. And Bridget, I'll turn it back over to you.
Great. Michelle, Ryan, AJ, thank you so much. That was really interesting, and I think very useful to our audience. I want to remind everyone that this is recorded and available to you via our website for subsequent viewing. Again, thank you all. Thank you for being such great partners to the IIB, and I hope everyone has a wonderful weekend.
Thanks, everyone. Appreciate you being here. Thanks, Bridget.
Thanks all.